Excellent. What I find is that we all know that we're mandated reporters, but we're not really exactly sure what that means. So today, I brought Dan Mack, who's the administrator of the Crimes Against Children Hotline, the Arkansas State Police, to come out and talk with us and tell us exactly what that means. So, here's Dan.
Welcome. Good afternoon, everybody. As David mentioned, my name is Dan Mack. I'm with the Arkansas State Police Crimes Against Children Division. And the division is actually broken up into two separate types of entities. We work together. We have the hotline, which is the child abuse hotline, which most of you will be calling to make reports. And then we have our investigation unit. And the investigation unit is a statewide, and it's got 10 different areas. We've got 73 different investigators. Our division is a sole civilian division within the state police. The only commissioned officer we have in our division is our boss. Our division commander is Major Jeff Drew. So if you go on the website for the state police and break it down to the divisions, you'll see the Crimes Against Children division and have a list of our supervisors and so on. So that's kind of where I'm from. To tell you a little bit about myself, I was born and raised in Chicago, Illinois. Moved here after graduating from college at SAU in Magnolia. Had plans of moving back to Illinois with my wife, and she had other plans and decided that I was going to move down here to Little Rock, and I've been here ever since. We've been married about 25 years and have 13-year-old twin boys. So we've had the experience of all the child abuse stuff, all the stories you hear, the different things that I've come across at my office, different things that you'll see and hear in the media. By legalities and confidentiality, I'm not permitted to speak about different things, but I can talk about different scenarios and situations that occur either at schools or things that you see on the news or hear on the radio. All of that typically has come through the hotline. So if you ask, hey, did you get that call, whatever, pretty much the blanket statement is if it made the news, it's more likely gone through our office. So that's just something that we kind of go through on a regular basis. So what we want to do today, it's going to be a very informal talk. I just really want to kind of educate you on really what your roles and responsibilities are as a mandated reporter. We'll talk about the different forms of child maltreatment that we encounter on a regular basis, how our daily days go at the hotline and what we do and everything. So if you have any questions, very informal, just shoot your hand up there, ask it, and we'll go ahead and address it right when it goes on. So I'll follow along with the handouts that you've got and also with the presentation behind me. The Child Abuse Hotline is a nationwide toll-free number. We're functional 24 hours a day, 7 days a week, 365. We never close down, we never shut down. We don't get to come in late if it's inclement weather. We don't just go ahead and arrive late or leave early. Whenever there's a governor proclamation about inclement weather policies and government offices being closed, that's everybody except the hotline. We are considered emergency essential personnel, so we are either to try to come into work if we can't make it to work. As the hotline administrator, I have a pool car that I have access to. If I can drive them and get them to work, I'll come by and pick them up. If I can't make it, we have state troopers at our disposal. And in severe situations, we call in the National Guard. So we will always have somebody at the Child Abuse Hotline. We are mandated to be there and operational and functional 24/7. As mandated reporters, you have the luxury of either calling the hotline or you can fax in a report to the hotline. Years ago, when I first started, this is my 21st year at the hotline, we had a very minimal staff. We started at the hotline, there was only 7 operators. We grew to about 17 when I first started there. And that was still, you had those operators spread out to cover a 24-hour day. So we were working in different styles. We could only work 8-hour shifts, so it wasn't like we were working 10 and 12-hour shifts. We grew to 22, we grew to 27, and now currently we're staffed to have 36 operators. We only have 33 right now on the phone bank. Those positions were awarded to us during the last legislative session, so we're in the process of expanding and hopefully getting that call weight down significantly. So about 5-7 years ago, we decided to let's go ahead and get a fax line in there. Several folks have asked about online reporting. Other states have gone to online reporting. Tennessee decided they were going to do that. They were the most recent ones. and everybody wanted online reporting. It'd make it easier for the mandated reporter. You'd access a portal, you'd fill out the form, send it on in, you did your job, you took care of it. The problem was they didn't account for the volume of mandated reports that were coming in. So they didn't increase their staffing. They figured they'd take a couple operators off in the phone bank. You guys are responsible for the portal, key in those reports, and send them out for investigation. They had reports sitting in the queue for upwards of 2 weeks because there wasn't enough staff to key those reports in. So online reporting is a beautiful thing if you have the staff that can key it in. So if we're keying it in and we're sending out for investigation, now you have to make sure you have enough staff out there to investigate this massive increase of all these reports coming in and so on. So we went with the route with faxing and said only mandated reporters are permitted to fax in reports to the hotline. We do receive anonymous faxes and anonymous reports from folks. We will key those. The problem is there's not a two-way communication line between the reporter and the hotline. So the reporter will never know what's happened with their the information that they send to the hotline. As a mandated reporter, we're going to ask you for your name and your title, what agency you're affiliated with, what the address of that location is, your phone number, and then most importantly, your fax number. Because that's how we're going to reply back to you. We are mandated by policy to reply back to a mandated reporter within 2 business days. So we have a 48-hour turnaround to let you guys know this is what we did with your report. If you call us, we'll tell you before you get off the phone, hey, your report's going to be accepted for investigation for these allegation types, and it's going to be sent to this investigative agency, whether it be the State Police Crimes Against Children Division or the Department of Human Services, Department of Children and Family Services. So either one of those two is going to be investigating your allegation. If you fax it to us, we will fax reply back to you, your name, and your agency, and tell you the disposition of what we did with your report. So you will have a physical copy of it if you have a good fax number that you supply. If you don't supply a fax number, we're kind of stuck. We don't have the resources to play phone tag for 2 days trying to get a hold of you. If you're a mandated reporter, chances are, if you're working in the school system, you're only going to be there from 8 to 3. It's a small window. And then we have those kind of issues to deal with. So faxes are always nice, provided it's you just provide all the information that we need. We'll talk about those a little bit later. As a mandated reporter, you guys are mandated to go ahead and now call the hotline. All of your jobs will be doing that. As far as after you graduate, what are your plans afterward? Where do you plan to work? Throw out some locations or some agencies you guys plan to work for. Anybody want to work for a hospital? Anybody plan to work at a school setting? Anybody plan to work for a mental health professional? Okay? Every single one of those professions requires you to call the hotline. More than often than not, the social worker is the one that's going to make the report. If you work at Children's Hospital, you'll be on a first-name basis with our operators. If you work the midnight shift, you guys will probably know all about our kids, we'll know about your kids, we'll know what you guys have for dinner and everything else. We're on a pretty familiar basis with children. So most hospitals will say, social worker, you're going to go ahead and call the hotline for us. So we're going to be pretty familiar with that kind of. So schools, all the MHPs, all the hospitals, that's where you're going to be doing is calling us. So you have to make a report. If you do an internship, if you work for one of those agencies, you will be contracted to go ahead and call the hotline. David and I were talking just a little while ago, and he said, when he was interning, he was made to call the hotline as part of his training. So a lot of the social work interns will call us and give us their information over the phone, or they'll go ahead and fax a report into us. So what do you have to call a report to the hotline? You don't have to have proof. You don't have to have evidence. You don't have to be the witness to the incident. You just have to have reasonable cause to suspect that something happened to this child. So again, you don't have to have proof. You don't have to have evidence. You don't have to be a witness. You have to have that reasonable cause to suspect that something has happened to a child. So when we get our information, The social worker isn't necessarily the first person who hears a story. And I'm familiarizing myself with a hospital setting. The child comes into the ER at Children's, and they have a broken arm. 3-year-old child. Mom and dad are there. Mom, dad, what happened to the child? Oh, she fell out of the tree. Oh, little girl, what happened? Oh, I was climbing the tree and I fell. Okay. They go to talk to the doctor. Same story. Social worker kind of comes in. Similar story. Mom and dad are taking him so the child can go get x-rays. Mom and dad are talked about over here. Maybe mom and dad are separated. Mom, what happened? Oh, yeah, we were out there and she went ahead and climbed and got a little too high and slipped and fell. Dad, he'll be in this different room. Same story. Ask the child, what happened? Oh, well, I went out to climb a tree. I was supposed to be taking a nap with mom and dad, but I woke up early and I went outside and I climbed the tree and I fell. Where were mom and dad? Oh, they were still inside asleep. So we'll get that information second, third, fourth hand. We go with the original source. Who was the source of that primary information? We had mom and dad's story and we had the child's story. As long as the child is the one disclosing the information, or someone who witnessed the incident disclosing the information, they may send it down the line 2 or 3 or 4 stories. We're okay. We want to originate that from the point of origin, whether it be the victim child themselves, the offender, him or herself, or someone who witnessed the incident and is aware of the situation. We get a lot of reports from our schools that same way. Kids will tell other kids what happened. The one who tells us, hey, I'm going to go tell my mom, or I'm going to tell a school teacher. The school teacher will tell the school counselor. The school counselor will go ahead and tell maybe the principal or the assistant principal, and eventually a report's made to the hotline. So you don't have to be the witness, you don't have proof, you don't have to have evidence. You just have to have reasonable cause to suspect something's happened to the child. There is a list of mandated reporters. By what you can tell on the slide, all of the positions that we deal with that are mandated are going to have some type of profession dealing with the child. You're going to have contact with the child in a variety of different ways. So the state has deemed everyone who does will go ahead and call the hotline. And social worker is on this slide, bottom left. So just by the fact that you're going to choose that profession makes you a mandated reporter. You can't get out of it. It will also include volunteer positions. You could be victim advocates at law enforcement agencies, sexual abuse victims at crisis centers, MHPs, and so on. So it does incorporate quite a few professions, some 42, 45 professions. You cannot be prevented from making a report to the hotline. If you're fully aware of an incident going on, your boss, your trainer, your supervisor cannot tell you, don't call the hotline. That's against the law. When I first started working at the hotline, we had that going on like crazy, especially in schools, in daycare settings. It was seen, well, come tell so-and-so, they'll do an internal investigation, and if they find something is reasonable to suspect, then they'll go ahead and call the hotline. It was really just deemed they didn't want to have the black eye against their agency, against their daycare center or their school. So a lot of the rules, the laws have been changed to include that part as far as being under contract. If you're obligated to call the hotline or make a report, you cannot be prevented from making a report. That's against the law. Some reporters get real nervous about making a report to the hotline. I don't want to get sued for providing false information. I don't want to get in trouble for calling the report. What if it's not maltreatment? What if it's an accident? What if the little girl fell out of the tree like mom and dad said she did? Whatever the case may be. As a mandated reporter, you're first of all required by law to make a report to the hotline. If you receive that information and you believe that report to be true or the information to be true, and you make a report to the hotline in good faith, then you are exempt from any kind of criminal or civil liabilities. You have to make that report in a good faith judgment. If you believe this is what's true, someone's coming to you and say, hey, I know what you do for a living, I know you work for the hotline, or I know you're a social worker, this is what's happened, what's on, what should I do? You deem say, well, that's a report that needs to be called into the hotline. I'm a mandated reporter. I have to call that and make that report now. You pick up the phone, you call the hotline, you give us the information, tell us who you are, who you got your information from, and the investigation will go on from there. If they contact your source, well, I never told so-and-so that ever happened. That's still information that's good. They would have to prove that there would be an issue with something being made falsely. If you knowingly make a false report, that's an entirely different story. But if you make a report in good faith and you believe it to be true, then you've done your job. Again, this reiterates the issue of mandated reporters cannot be prohibited from making a report to the hotline. If you start working at a school, or you're familiar with some of your school teachers, if you have children, you go in and see the children and so on, and you're familiar with teachers, schools are not required to notify the parents or the guardians of the children in regards to a child abuse report. It's actually preferred because oftentimes the offender of the child abuse report is going to be one of the parents or one of the guardians. So as an investigator, when they go into a school, they will ask to get so-and-so person out of class if they have to. That's usually not the desired point of interview. It's usually not desired for them to pull a child out of school or out of class in front of their peers and in front of a lot of public area. We try to go ahead and it would be more of a situation to isolate the child, get them away from the school setting. But sometimes due to time constraints, if it's 1 o'clock in the afternoon and they have a potential to go home to an environment where they're going to be possibly abused again, then we're on the clock. We're going to think about the safety of the child first as opposed to whether or not we need to pull the child out of class. So schools are not required to contact parents or guardians to let them know that their child, this situation is going on at the school. So that's just another thing as an FYI when you decide to work out for a school. More about the good faith. As mandated reporters, oftentimes you're going to share that information. At the hotline, we can't. All reporters have their anonymity protected. We can't give that information out. An investigator is not going to go to a family and say that Dan Mack at the Child Abuse Hotline called us in and made this report to you. They will be made aware of the allegations brought forth to them, but they're not going to be told who made the report. When we key a report into our system, we do as much as we can to de-identify the reporter. We talk in the third person. We never describe who the reporter works for. We try to describe the reporter by gender, by their agency, by their name. We'll just say the reporter said and leave it at that. So we're basically just a narrator telling a story that was coming from this party, and we'll leave it alone with that. So you should never have to worry about making a call to the hotline or report to the hotline and worried about your name being given to the family. Now, that information being provided may only reasonably come from somebody at school, and the parents or the offender may deduce that, oh, I know you called the hotline, I know it was you. No one's going to tell them and confirm, yes, you called the hotline. They're not going to give out your name for that. If they do, they've broken the law, and that will be punishable by a criminal offense. Got it. Again, more about unlawful restriction of child abuse reporting. So what do you have to make a report? First thing you need is the allegation. Whatever you believe to be child maltreatment, you're going to call into the hotline. The second thing that we're going to need is a way to locate that victim child. We have to know where to find this child. We can't go on a city. We can't go on a description, or maybe there's this girl and then they attend so-and-so school. We really need specific names if at all possible. So we're going to ask you for some very specific information: the child's name, what their home address is, where they go to school if they don't have a home address, if they're daycare age, where they go to daycare, if there a phone number to the residence, whether it be a landline or a cell phone. We'll go with that information. Maybe you can just provide physical directions to the home. Maybe you're a neighbor and you just know where they live. You know the house number. Or maybe you don't know the house number. Does the family receive any kind of services? So those situations can help. Regardless of whether school is in session or not, school is still a viable place to find a child. So we can get that information from you. So that's the kind of information that you're going to be asked for when you make a report. So try to have that information ready. It'll help speed up the process a whole lot better for you. Again, we talked about having the reasonable cost, the probable cost to make a report. You can make a report, as we mentioned, by the 800 number, by the fax number, and there's also an 844 Save a Child number that was created by the governor's wife a couple of years back to make it a little bit easier to report and to remember. For us to accept the report in Arkansas, we have to know that A, you have a valid allegation, but B, the incident occurred in Arkansas. Arkansas is the only child abuse hotline in the nation that operates under a law enforcement umbrella. Every other hotline in the country operates under their DHS, the Department of Human Services, Department of Social Services, Department of Children and Family Services, whatever they're called. So if you call another state's hotline, that's where you're going. The hotline used to be under the DHS jurisdiction when it first started back in 91, 93-ish time, before my time. So by the time I got to the hotline in 99, it was already transferred to the state police. It came over to the state police around about 96, 97 when legislation was done. DCFS had a child maltreatment investigative unit, and they had a special investigations unit that dealt with the severe maltreatment issues. Severe sexual abuse, physical abuse, or child death reports went that way. So now we still operate similarly, only DCFS operates the less severe maltreatment allegations, and the state police operates the criminal aspect of child abuse. So anything that's going to be perceived as possibly leading towards criminal prosecution will be assigned to our division of the state police, the Crimes Against Children division. So that's how it was divided. So we operate, if the incident occurred in Arkansas, then we have jurisdiction to investigate it. The other issue is if the offender resides in Arkansas. If they have an Arkansas address as far as their locating information, then we can say they're a resident of Arkansas. We will investigate that as well. If the incident occurred out of state where the offender resides, maybe the child was on visitation with the non-custodial parent during spring break and they came back to Arkansas and say, well, when I was there, this happened to me, we would transfer it to that state because they would have criminal jurisdiction to proceed with an investigation. The other states operate just the opposite. They can only do an investigation if the victim child resides in their state. So sometimes we have a stalemate when it comes to a child maltreatment investigation. We can't investigate it because it didn't occur here and the offender doesn't reside here. They can't investigate it because the victim child doesn't reside in their state, they reside in Arkansas. So we would refer the reporter to local law enforcement where the alleged incident occurred and then go the criminal route. So there's always an avenue to go. Child abuse is child abuse. It's just who's going to work the investigation, whether it be a child maltreatment investigation, whether it be only a criminal investigation, or whether it be both. Because you can have a child maltreatment investigation and a criminal investigation. Both can be founded true, one can be founded true, one can be founded unsubstantiated, and not go to court or go to trial. A few years back, we had some incidents with, actually several years back, with schools being threatened and threats of violence at a school. And we've all seen the news over the past 25, 20 years of things actually coming to real life. You have massive school shootings and you have other issues of violence here and there and everywhere. Threats being made, and some of the threats weren't being taken seriously. And mandated reporters were aware of these threats. They were being made aware by students. They were being made aware by parents. They were being made aware of social media posts. Oh, well, that's just somebody blowing off steam, and it's not that big of a deal. And then something happens. So laws were written, things were changed about how to report those. So as a mandated reporter, if we're aware of those violent threats, we want to know about those. Whether they come to absolutely nothing is beside the point. We still want to get those processed into our system. More than likely, if it's not a child maltreatment issue, we'll forward on to local law enforcement and let them look into it. And everyone has heard different things. We just had an incident last week. We're at Sylvan Hills. And lo and behold, no one knew what was going on, but then 6 or 7, 8 teenagers got arrested. They didn't know that the FBI was going to be involved, and then it just kind of blew up. It all pretty much started as a prank. So the pranks are now something that have to be taken seriously. The state police deals with, we have a division called the ICAC, the Internet Crimes Against Children. So even though it may not be something that is physically right there in front of them, it's still going to be looked into by some source or some agency. So the FBI will get involved with physical threats of violence. As a mandated reporter, if you're made aware of them, just make a report to the hotline. Child maltreatment really is broken down into 5 separate categories. You have abuse, you have neglect, sexual abuse, sexual exploitation, and abandonment. And really, abandonment and exploitation are really their own 2 standalone allegation types. Abuse, neglect, and sexual abuse are a little bit more broad. When you mention child abuse, a lot of folks will think of physical abuse. Some will think of neglect and things that kids don't have, and then rarely will the mind go to sexual abuse, which is okay, which is good, but it's still a part of reality that we have to deal with at the hotline. When you're dealing with abuse, you're looking at something that is intentional. Something intentionally, not accidental, happened to that child. The scenario I mentioned earlier about the little girl falling out of the tree. Yes, she had a broken bone. By agreement, a child with a broken bone should be investigated by the Arkansas State Police Crimes Against Children Division. Because if it's found true for abuse, then that could go to criminal charges. But in the scenario I provided, the child wasn't physically abused. She wasn't assaulted by anybody. She broke her arm because somebody wasn't watching her. They were neglectful and keeping an eye on her, and she fell by accident. So injuries received by accident, and you believe the story to be accidental, would not be something that would be reportable as an abuse allegation. We're looking for something that happened intentionally to the child. Child comes to school with a black eye, reports he got slapped in the face by dad because he mouthed off to his mom. It was an intentional action by the parent to go ahead and strike the child, which resulted in the injury. So at the hotline, we'd register the injury, physical abuse, so that would be a cuts, bruise, or a welt. And then we would register the allegation that the striking incidents that he was struck on the head or face. If the child was punched in the face, then we'd add striking the child with a closed fist. So we look at situations where the child was intentionally hurt. Parents, when they are talking, will say, oh, well, you can't spank your child because DHS will take them from you. Not true. If you spank your child and cross that line and leave injuries, then you open up the can of worms for possible investigations to possibly lead to a child being removed. DCFS doesn't want to remove a child from the home. The most traumatic experience you can put a child through is take your child from their parent. All they want is for the stuff to stop. They want the maltreatment to stop, they want the abuse, the neglect, whatever it is to stop around them. But they still love their parents, for the most part. So that's probably the last thing that goes on with that. So for abuse situations, we're looking at what happened intentionally. If an action happened directly that resulted in injury, then that's what you have. If you don't have that intentional injury, but you would look at a situation where, okay, the child has this, and they say, oh, well, I fell off my bike. Does the injury look like the child has received it by falling off of a bike? So you have those situations. Children, especially if they're younger, are usually either going to be painfully truthful or they're going to be horrible at lying. And as a mandated reporter, you're going to know your kids. You're going to know who you're talking to. You're going to read that body language, see their eye contact go to the floor, see their face, flush red, and they're going to talk more softly, and they're going to make you up a story. So we're going to ask you, do you believe the story happened the way the child said? No, I really don't. Child lost eye contact, turned flush red, started crying. My dad told me to say whatever. So we're going to ask you, is the history at variance with the story provided? Medical staff is great if they have a physical injury and they say that's not medically how that child received that broken arm. It's a spiral twist or whatever, the child was picked up and grabbed, that's what resulted in the fracture not falling out of the tree. So as a mandated reporter, you're going to be asked for your professional opinion. We're relying on you guys to make your professional judgment. A, you know your child. B, you're right there in front of them. You've got to paint us the picture of what you're seeing. Here's some examples of physical abuse that could result in an accepted report without a physical injury. Around about 2007, they threw in these action allegations. You can't strike a child in the head or face. You can't slap them across the head or face. Pop them in the head or the face. You can't punch them. You can't kick them. You can't throw them. All of those actions were in there, but they were never an accepted allegation unless there was a physical injury. So now they said we're going to have these allegations in there, and they can be accepted with or without causing you physical injury. You know, as a child growing up, I had a smart mouth, and I didn't mind expressing it. So a quick backhand to the chops or to the back of the head would straighten me up, but you can't do that now. There's things that happen to us as children, and probably your teachers and your professors, when they were kids, that would be, I mean, they'd throw half of us in jail. So those are situations that you have to look at it and go from there. So times have changed. There are certain things that we can no longer do to a child because, again, that's going to be a maltreatment issue. If a child is spanked, if they receive a bruise on their butt and it's accepted for investigation, it's up to the investigator to determine whether or not the discipline was reasonable and moderate. So just because a report is made to the hotline doesn't necessarily mean that it's going to be founded true and that child's going to be removed from the care. If the reporter believes maybe it was a one-time deal, it wasn't that hard, the bruise was faint, it went away, it was a reasonable and moderate situation, they may deem it as such like that, and there's basically, the family would be kind of put on a warning, if you will. Make sure nothing happens in the next, 6 to 12 months, and then you'll probably just kind of go away type of situation. So injuries can be resulted, but they can still determine to be unsubstantiated because of the reasonable and moderate part. It was done in the form of a disciplinary action as opposed to being just an everyday abusive situation. Transient pain and marks are very similar. So just because a mark is going to disappear or they're going to experience some transient pain doesn't mean that it's not maltreatment. But it doesn't mean also that it's going to be accepted for investigation with a true finding and the children removed from the care of the family. It's really up to the discretion of the investigator. Some of you may go work in a school. In Arkansas, it was kind of a culture shock for me. Growing up in the streets of Chicago and coming down here, my envision of Arkansas was the movie Deliverance. So it was pretty much skewed. And then when I came down here and actually went to South Arkansas, Magnolia, you realize this really is Deliverance. And I've since, actually changed my ways. So when you have situations like that, my friends would talk about, when they were in school, they were paddled. And there were so many paddling stories. And this was in rural Arkansas, Magnolia. So there were a lot of schools around there that dealt with the paddling issue. And I said, sure, that's just a myth thing of the past, whatever. So no, it's really true. So when I do my talks to school personnel, we kind of emphasize the deal about, as a mandated reporter, if you're given permission to paddle the student, that's fine. Just remember, if you leave injuries on that child, you're going to be named as an offender in the child maltreatment registry. Doesn't make a difference if mom, dad, or guardian or grandma says, go ahead and tar the mess out of that kid. Whip their butt. Paddle them good. If the injuries result from there, that puts you and your profession and your job on the line. And we have had teachers, principals, coaches, school personnel lose their jobs because they were on the registry for a true finding because they were paddling their students. So just be aware of that it is a criminal offense to do that, along with, as well as child maltreatment. If you work at a mental health facility, Rivendell, Charter Behavioral, some of the facilities, Centers for Youth and Family, places where kids are either adjudicated or they're sent for behavioral issues. The staff there is trained to take disciplinary actions accordingly. How to do takedowns, how to grab a child, how to restrain a child. If a child receives injuries during the course of any of that, that's a report to the hotline. We don't have access to video cameras, to security recordings or anything of that nature. So that will be something we would tell you, that will be something to present to the investigator. If the child says, Mr. Jim went ahead and slammed his head against the wall and he's got a knot in his head and it's bruising, then Mr. Jim is going to be put on our registry for cuts, bruises, and welts and for striking a child on the head or face. The video can very well show that the child was self-mutilating, was banging his head against the wall intentionally by himself, and Mr. James came and restrained him and grabbed him and pulled him away from the wall and put him in restraint and a takedown. So that's how the story can go ahead and change and how it's presented to us. We have to go based on the information of what's presented in fact, what we believe to be fact, and then the investigator will say, here's the proof of the evidence of what didn't happen. Okay? We know we're getting the story at the hotline. We don't know if we're getting the true side of the story or we're getting the false side of the story. That's why the investigators have to go ahead and earn their keep. Up until the last couple of years, there was no entity in Arkansas that tracked any child death. If someone wanted to find out how many child deaths occurred in the state of Arkansas in 2013, they would have to go to each and every county, all 75 counties in Arkansas, and ask the coroners, the medical examiners, about the child death reports. So in 2017, they passed some legislation to say all child death reports have to go through the hotline, and we will document how those how they get basically keyed into the system. If a child dies by medical reasons, they were in a hospital, they were born premature, and they died 7 days later, and they never left, that would probably be something that would not be investigated. But any other circumstance would be investigated or at least looked at to as an assessment by our division. Some children will die due to single car accidents. We want to know, we might want to assess why was a child in that situation. Was a child, did they have any mental health issues? Were the parents possibly negligent in getting the child mental health issues? Children who commit suicide, why do they commit suicide? Children that are involved with co-sleeping issues. Parents should never sleep with their babies. They should never have other things in the crib with their babies. They should never have pets or other siblings sleeping in there. That is one of the number one of the highest growing rates that I see at the hotline of child deaths under 6 months old are babies sleeping with somebody. More often than not, the baby is sleeping with their own parent. And the baby gets smothered, and then they call us. Neglect is pretty straightforward. Who is not providing something to the child? What does a child have to have when they're growing up? Food, water, shelter, clothing, education. So those situations are looked at as, okay, who is responsible for that? The parent or the guardian, or something that we call the PRFC, the person responsible for the care of the child. So when you make a report to the hotline or you fax in a report, you'll check mark the box PRFC. That's what that stands for. The PRFC is the only one that can be named as the offender for neglect. When you're dealing with an abuse report, the PRFC is someone who can be listed as an offender. Someone who's 18 or older living in the home with the victim can be an offender. That would include adult siblings and relatives. And then the third person for abuse would be mom or dad's significant other, whether that person lives in the home or whether or not the new caregiver around. Who here has children? That's one. Who here has ever babysat? Y'all keep your hands up if you already answered yes. So just about everybody so far. So everybody here could be listed as being on the registry. You can change that out. Myself included. So when we have kids come through and they're in Job Corps, they're in summer programs, and they're upper teens, juniors, and seniors, and they're talking about what they want to do career-wise, we basically present that to them as well. If you're 14 years of age or older, and you're in a caregiving role of a child, and you physically abuse that child, you can be put on that registry, even if you're not the child's parent. Okay. So there's certain circumstances that kids have to understand, and as parents, you have to understand if you place a child in care of your child, you're responsible for that person. So if you allow a 17-year-old to come into your house and they physically abuse or neglect or sexually abuse a child, that puts an open for the parent. So a lot of folks will just kind of grab any random teenager in the neighborhood because they think he or she's a good kid, they get good grades, but check out the kid just to make sure. If you're aware of a situation that's happening to a child, particularly if you're a parent, and you're not protecting that child, you could be guilty of what's called failure to protect. We get situations where you have a battered spouse in the situation, and they're getting beat on, and the child is trying to defend the parent, and then the child gets beaten up by that. So if you're aware of the situation and know of maltreatment to a child, it's your legal responsibility to protect that child at all costs. For those of you who will be working in a hospital setting, Garrett's Law was passed March 28th in 2005, and it looks at children who are born drug positive. Either the baby or the mom or both will test positive for an illegal substance. They don't have to test positive for the same substances, but they do have to test positive the day of birth, plus or minus 24 hours. Mom may be admitted at 3 o'clock in the afternoon and tested positive, doesn't give birth till 12 that day. That's fine. It's within the 24-hour window. If mom or the baby don't test positive, but there's history of mom doing drugs during the pregnancy, testing positive during the pregnancy, oftentimes the hospitals will send off the cord. So you have a cord test, a placental test. You could also have a meconium test after, if they don't capture the urine sample, they'll capture the first poop. They'll send that off, and if it comes back positive, then call back to the hotline, and you can make a report that way. Overwhelmingly, our reports from hospitals on Garrett's Law come from the social worker. As a matter of fact, when this law was first written and it came out, it was passed March 28th and went into law in July. By August, they had to go back into an emergency session because they forgot and left the social worker off of the list. So the mandated reporter was the obstetrician, the pediatrician, the physician, the hospital admission staff, but nowhere on the list was the hospital social worker. So they had to go back into emergency session and say, we need to add the social worker because that's who's making all the reports of Garrett's Law. Sexual abuse, by far one of the more challenging aspects of the Maltreatment Act to grasp, just because it changes periodically. It changes just about every other legislative year. Thankfully, it didn't change this year. It has changed quite often since. So what we're looking for, it's broken down into 5 different types of sections. And it's kind of scrambled on the screen. The first one that we deal with primarily is the forcible compulsion, a rape situation, something that is non-consensual. So your victim is 17 years of age or younger, and your offender is 14 years of age or older. The youngest an adult offender can be put on our registry is at 14. So you're looking at a situation that is non-consensual. No means no. Even if no started out as yes and consensual and kissing and so on, the minute it turned into a no situation, that's when it has to stop. If it proceeds after the fact, then we have a situation. If drugs or alcohol are involved, we're going to ask you for your input as to the situation. Was the victim able to consent to the situation? We have reports of children being drunk, and they're going about and they're involved with, starts out a consensual situation, and they don't know if they gave consent to have sex. They don't know how they ended up in the bed naked next to somebody. So we have to bring it to the reporter and say, what do you think? What's going on? Were they able to consent? Were they not able to consent? There is no minimum young age in Arkansas to have sexual relations. We've had children, girls as young as 9 come up pregnant, and their partner was 10 or 11. So that has happened. Those are realities. Who do you make the offender? If it's a situation that happened and said, well, we're boyfriend and girlfriend, and he said that they would do, this is what his older brother and her girlfriend do, that you want to try it. Okay. And they try it, and they have sex, and she ends up pregnant. So it becomes more of a social issue than it does a maltreatment issue. So we're looking at the part of, was there truly somebody who was raped or forced to do something? We'll look at forcible compulsion by force, threat, or intimidation. Were they coerced into something? Were they made to do something against their will? Otherwise, there would be consequences around it. When we also look at sexual contact, we look at specific areas. Where was a child touched? We look at the female breast, the buttocks, the vagina, the penis, and the anus. So those are specific areas that we're looking at. We can't take reports on sexually assaulted, sexually molested, or inappropriately touched. We really need to have something specific because we need to know kind of what the frame of reference is from that child. If a 9-year-old child reports to their school counselor that they were raped over the weekend, what is that child's understanding of what the term rape means? Is it really sexual contact? Do they mean sexual intercourse? Or what? Oh, well, the man the boy came on top of me and he kissed me on the mouth and raped me. Inappropriate, yes. Unfortunate, yes, but not maltreatment. So we have to get that frame of reference from you as the reporter about what happened in the situation. If kids are too young, were they old enough to consent? 10 years old consenting to have sex with a 17-year-old. A high school freshman with a high school senior. An 8th grader with a senior. Is there something about the younger child that would not really give them yield to consent to something? Do they understand with what they're doing? Is there a size difference? Is there any kind of a situation of bullying going on in the school where they felt fearful or intimidated by the subject and go from there? So we're always going to ask you about the ability of the victim to consent to something. Other issues we look at would be the age. Even if you have a consensual situation, to consent to have a sexual relationship in Arkansas with any adult, you have to be at least 16. So we use the ages. If you have a consensual relationship between a 14-year-old or younger with an 18-year-old or older, that's against the law. Even if the 14-year-old consented to. We have a lot of situations where younger kids who are 14 or younger are consenting and having sexual relationships with adults. So it is against the law. If the child becomes 15 and they have a consensual sexual relationship, the offender can't be over 20. Child maltreatment law says that's too far of an age gap, that's too old, so at 20 is where it's capped. Actually, it's 19. 20 is when it becomes an offense. Okay? Years ago, siblings were on the registry. You couldn't have consensual sex with your sibling. Now you can. They were seeing through investigation that if these siblings were of similar ages and they were consenting to have sexual relations, it wasn't being found true for maltreatment. It is a criminal offense. So there are some things that are child maltreatment, and there's some things that are criminal. The laws don't overlap exactly. The other situation that a child cannot have consensual sexual relationships with their caregiver. So outside of the caregiver, outside of the family unit, moms, dads, step-parents, grandparents, aunts, uncles, outside of the family, what would you think would be a more popular PRFC or caregiver relationship with the child? Throw them out there. Think of your situation. Do that. Teacher-student relationship. That's the number one caregiver to student, caregiver to child maltreatment what we have for sexual use. They're consenting, but the teacher cannot have a sexual relationship with their own student. They can't be in the same school at the same school district. If it's outside of the school district, that's a different situation. Child maltreatment doesn't look at persons in position of authority. That's a criminal terminology. We deal with people who are in a caregiving role. Teenagers who are having consensual sexual relationships with their bosses at their jobs. You get a 16-year-old teenager, she works over at McDonald's or Sonic, and she's sleeping with a 21-year-old manager. That's not us. That's a consenting. She's 16, he's 21. That's a consensual relationship. Criminally speaking, law enforcement says that the age of sexual consent is 14. So they say 14, we say 16. We don't overlap exactly on top, so it causes a lot of confusion. The number one thing to take away from this training, if you remember anything, is when in doubt, make the call. Do not get stuck, do not lose your job, do not get thrown in jail or face criminal, any kind of charges or prosecution because you thought it was in a report. Unless you have this thing memorized, and I've been doing this for 21 years and I don't have it memorized, make the call. You're not going to waste our time. You're not going to go ahead and do anything but get your name put on a report that you made it in good faith, and be done with it. We've had teachers in situations who thought they knew the law, did not make a report to the hotline, and then they got criminally charged, they lost their license, got put on probation or thrown in jail because they misinterpreted the parts of the law they thought they knew. So don't get stuck in that kind of a situation, regardless of what the allegation type is. The law says you have 48, you need to make a report immediately. The judge determined that to be within the first 24 to 48 hours. A caretaker, as we mentioned, parents, adults in the home, anybody the parent deems to be a caregiver, school personnel, daycare personnel, those adults that are working in those situations. So social workers, as you go work in a school setting, you're going to be considered a caregiver of that child. Doctors and nurses and medical staff are considered caregivers because typically the caregiver is taking the child to the appointment. Law enforcement officers, same thing. If they physically harm a child because they're acting in their official capacity as a law enforcement official, an SRO at a school, they are exempt from the PRFC status. If they harm or physically harm their own child, that's a different story. I'm just going to get through some of these here towards the end. Adult victim reports are rare, but they do happen on occasion. So there's 4 criteria when we accept a report from an adult victim. First of all, the victim has to be at least 18 years of age or older. The allegation is a sexual abuse of nature, but occurred when the victim was a minor. Thirdly, the alleged offender must be a current caregiver of children. And then fourth, the reporter has to be either the adult victim, the alleged offender, or a member of law enforcement. So the scenario that I gave you about a student having a sexual relationship with their teacher, that actually happened a few years back. The child was 19, had a sexual relationship with her basketball coach. The basketball coach was still in the same capacity at the school. The relationship ended, it went south. The 19-year-old made a report to law enforcement, and law enforcement made a report to the hotline. Because that offender was still having access to minors, that made that person still at risk. So that's something that, just as an FYI, when you're dealing with your different positions and different agencies that you work with, you may encounter adult victims. There still is some course of action if an adult victim was sexually abused as a minor. Abuse and neglect doesn't come to the hotline, that will go to a criminal aspect of it. Confidentiality, everything at the hotline is strictly confidential. It is not FOIable. Somebody can't come and request records. People who make reports can't request a record because they want to have a copy of their report so they can take it to court for the custody hearing that they're going to have against their ex-spouse. They have to be basically opened up by a judge, or the prosecuting attorney can subpoena the records. If they subpoena our records, they're also going to be entitled to any of our notes as far as reports that we make, or any of our digital recordings. All the calls made to the hotline are recorded, so that's always a saving grace for a mandated reporter. However, if you call and remain anonymous at the hotline, that basically releases you from your obligation. You did not obligate yourself to making a report if you remain anonymous. There's no way to link your name to a report. So as a mandated reporter, you are required to call the hotline. If you choose to remain anonymous, that takes all that information off of the report, and you are just listed as anonymous. So just be aware of that. We have had certain situations where the mandated reporter didn't feel comfortable giving their name, felt they were fearful of retaliation, But then when it came time for them to know about, oh yeah, I made the report to the hotline. Not unless you left your name and gave all your information. Okay. As was mentioned, the hotline was created back around '93. Back in the day, if you wanted to make a report to the hotline, you called your county DHS office, and that county DHS family service worker would take your information. There was 75 different offices, 75 different interpretations at least, so there wasn't any kind of continuity to figure out what was going to be acceptable and what wasn't. There was need for a central intake unit, hence the creation of the hotline. We make the determinations. As an operator, when you become an employee with us, we tell you up front, you will be making determinations of whether or not this is or is not child maltreatment. Tell you some numbers there. We are considered to be an operator. We get the privilege of getting a lot of our applicants from the social work field, psychology field, criminal justice. So we see a lot of you guys coming in after graduation. We are considered entry level. Sometimes if you go to DCFS or try to be an investigator with our unit, you're going to be turned down because you don't have the field experience. My first interview was to be a crimes against children investigator. I wanted to go out and investigate child abuse, but I didn't have the NQs. I was a college graduate with a degree, and I had 8 to 10 years of retail experience, but no field investigative experience. They said go to the hotline for a year or two, come back and then re-interview, then we'll go ahead and put you in the field. I liked it, I stuck with it, and I'm happy with the choice. So wherever your personal life guides you, that's kind of what happens. So if it comes to the hotline, we'll be more than happy to educate you and teach you. It just depends what you want to do in your life field. Some want to become investigators, some want to work at a hospital, some want to work in a mental health facility. It really just depends on what y'all want to do. That's my song and dance. There isn't any more unless y'all have any questions. Feel free. If you've got questions, now's a good time to ask. I know you guys are pressed for classes and so on. So hopefully I answered as many questions as I could for you. Anybody? Yes, ma'am.
So you said the important thing was that you that you might be asked your professional opinion about it, and that you're supposed to have reasonable suspicion. So I was working with a foster kid a few weeks ago that was telling me that she had been raped by a stepfather. But we know that this child is prone to telling stories, not just lies, but big elaborate stories. And then the way she told it, the time period that she gave, the age that she said when it happened a year ago, she hadn't even been around a stepfather in like 6 years. She'd been in the foster care system for the majority of her life. She was 9 at this point. And so I just kind of figured it was really nothing, but I went to my supervisor and she had me go ahead and call it in. But I just felt like I had no suspicion that anything really happened to this child.
And we get those reports a lot. We get the situations where you have the children who will fabricate, particularly when they're in foster care. If they'll go from either behavioral hospitals or from house to house to house, they'll just keep telling the story and retelling the story. So we look at situations, more than likely the first 1 or 2 times it was probably investigated, and then now you've got to rehash it in certain circumstances. And if you know the timeline doesn't match up. She said it happened last year, but she hasn't seen the offender and so on. So we document the information, and we'll ask you, do you believe the story to be, the viable? So we will ask you that because you know your child. We know that you're saying, yes, she's prone to making up stories. They get elaborate, they get this, they get that. I really doubt the validity of it, but I'm basically making the report. So if we have reporters who don't believe the story, but they're calling us to basically cover their backsides, we get a lot of those. We're going to ask you, do you believe the child, this information is factual? But if you say the timeline doesn't match up, we'll take down that information. And that's usually, again, using your common sense to say this really probably isn't anything. And we'll keep a history of all the reports made to the hotline. Those that are investigated will document in our document reports that never get sent for investigation. And you can see those. So sadly, we get a lot of those kind of things.
Yeah, I mean, I kind of felt like, gosh, you have real things you need to be taking care of. I don't want to waste somebody's time with this.
It is at that. You know, and as a mandated reporter, if you work in a setting where you have multiple people who are reporting the same incident, you know, we get those a lot. We'll have 4 and 5 reporters reporting the exact same thing because they all work at the same school or the same agency. And because you're mandated to do that, that's fine. Sometimes we can say you can get into one room and say, okay, I'm the reporter, but there's also these 3 other people that are here at Knowledgeable. They're also mandated reporter. We'll add those names into a separate field that says others knowing of the situation to report are, and get their names and their titles and their contact information. That kind of at least links you to that situation if you don't feel like making a report. That'll be all right.
What about, like, what is it, like emotional verbal?
Well, we deal with an allegation called mental injury. So when you deal with a mental injury allegation type, there are specific reporters who can make those reports to us. Daycare teachers, daycare workers, teachers, school counselors, and then mental health therapists, mental health professionals. You guys would know, they would know their students the best, their children the best, to be able to discern whether or not they're being affected by the verbal abuse or the physical abuse. And we want to find out, we have kind of a list of bullet points that we're looking for. If the child's having suicidal or homicidal ideations, what is their outward physical appearance, how is their social setting or their skills now compared to when they used to be. Grades have a lot of impact on stuff. Is it a bullying factor? Is it something that is being done intentionally to them? Mental injury is an abuse allegation. So either the caregiver, an adult in the home, or mom or dad, significant other have to be the offender. What are they doing intentionally to this child? Either saying something to the child or physically abusing the child that would cause this type of mental anguish. So what is being done to them, and then more importantly, what is the child's reaction and how is it affecting the child? So whenever we get information, yes, we have A, but we want to know what's the effect to be. If a parent is doing drugs or alcohol, if they come to school to pick up their child and they smell of marijuana, we're going to ask, do you know the level of impairment? Was the parent slurring their words? Were they staggered? Were they falling down, stumbling? Were they, you know, asleep in the car? Or they you know, in the drive-through or the pickup line? That would be a major concern. But you have functional addicts, you have functional alcoholics who can be under the influence, and they're just that, they're under the influence. Law enforcement officers, if they charge you with DUI or DWI, it makes a big difference. Driving while intoxicated, bam, you're on the hotline registry. Driving under the influence, that's going to be a criminal issue. If they don't charge them with anything like child endangerment or any type of welfare issues for the child. Yes, sir. Yes, ma'am.
I have a client, she had received some charges where she can't have contact with children under the age of 18. She stated that she got those charges in another state in New York. At this time, she's left from New York and came to Arkansas, and she's with a gentleman that now has children. He's recently gotten custody of his children. So
That would be a report to the hotline. For the sake, we have something similar to that in Arkansas, where if a registered sex offender moves in with the family, if mom or dad are aware of the sex offender status and that sex offender is living in the home, we can accept a report for failure to protect, even if there's no allegation or outcry by the victim child saying that he or she has been sexually abused. So in your situation, children who are removed from the care of their parent, and that parent is, as you mentioned, is to have no contact with a minor, that would be something that we would want to know. That's a pretty harsh, to have no contact with any minor. Even sex offenders can have at least access to their own child, provided their own child wasn't the victim. So that would be something that we would probably go ahead and look to accept. The problem that we would have is specifically what were those allegations up in New York. If children were taken away because of gross negligence, maybe a child died in her care, she was the offender in a physical abuse that led to a possible serious injury or child death, that would be something that would probably be going to look at.
There was some allegations where the child, her bones were broken. She had children after, she had at least one child after that, and the child was taken immediately.
Those situations, and yeah, we would do something similar. We would charge if the offender, if the dad, you said she moved in with the dad with the kids, if he was aware of that history, then we would charge him with failure to protect. We couldn't do anything against her unless she did something to the children she was currently with. But definitely, that's basically dad's putting his own children at risk, so that would be a failure to protect allegation. And that happened here in Arkansas just not too long ago, where we had a mom immediately had the child removed from her care because she was named in a child death case previously. So. Yes, ma'am.
I have a family member whose child is playing basketball, and they recently found out that one of the parents, he's real active with the other kids, but one of the parents is a sex offender. But he hasn't been left anywhere alone with the girls, but his daughter, plays on the basketball team too also. And so the parents are kind of like concerned about whether or not they should take their children off the team or not, or so is that would that be considered a problem that he's?
Well, the school will be they'll be opening up themselves to some serious issues. First, the sex offender registry is open, so you can go to local law enforcement. They'll have a listing of all the sex offenders in the area. What stipulations does he or she have that will prohibit them from going on campus? Are they excluded from being in contact with a child for whatever reason? Sometimes you have statutes of limitations where it's no longer, all those restrictions have been lifted. Definitely I would make the school aware of the situation, that hey, this is a situation, don't know if you're aware of it or you're not aware of it. Those are things that kind of, get things out in the know. But you certainly can, as a parent, I can say, hey, I've got this going on at my school. Can you tell me if this person's a sex offender? And then what can I do to protect my child? Sure. Yes, ma'am.
The situation is kind of similar to that. There was a known sex offender at the church that I attend, and he's like a stage 3, stage 4 offender. And I know the church, not the whole church was aware, but like the preacher and other members of faculty are aware. Do parents have to know? No.
Now, again, if there are some restrictions in regards to law enforcement, this is kind of outside my expertise, but if you move into a neighborhood, then if a sex offender moves in, I've heard they're supposed to register, and that's supposed to be made somewhat public knowledge. As far as where that offender goes to church or kind of meanders in there, whatever, go to Kroger, to Walmart, that's just kind of open for that. As long as, as a parent, I would want to make my pastor or my church officials aware of the situation, and I certainly would make my kids aware. It's okay, stay away from that man. My boys are 13, so they're 13 and know everything. So I'm kind of dumb to them, but they know what I do. And they know that if I say something about it, it's not because I'm an overprotective parent, so I kind of have that get out of jail free card. As a parent, if you're not involved with that situation, you don't have that precursor. It's like, okay, Mr. Dan said so-and-so. Oh, well, he's just being overprotective. So that's something that's, I've always tried to be open with the boys about that kind of a situation, because these things are real life. When I was a kid growing up, I said bye to my mom at 8 o'clock in the morning, and I was home when we had a street light in front of our house, and that street light came on, I better have my butt in the house. And that was it. Today, you can't do that. And it's a sad situation. But make the kids aware of it, make as many people as you know aware of it, so that they realize the situation. Sure. Yes, ma'am.
Are there protections for undocumented children and families?
One more time.
Protections for undocumented children and families?
We take reports regardless of the documentation. I know, unfortunately, because of the documentation issues, we don't get some of those reports. Northwest Arkansas, Southwest Pulaski County, certain areas, and it's not just Hispanics, it could also be some of the Vietnamese and Laotian crowds. So we will go ahead and register the reports. A lot of our reports will say that the family is Spanish speaking, and we need to speak with interpreters, so we'll include that information. But they're going to be processed in a maltreatment standpoint. Our emphasis is going to be maltreatment. what happens with all the immigration, all that stuff, I don't see that coming to, I've never been made aware of anything where they say, okay, you made a maltreatment report, so someone's going to be deported with the kids taken on. The main issue is just to stop the maltreatment. Okay. Anybody else? Well, awesome. You guys have been a great audience. If you have any questions, by all means, contact the last slide has the follow-up information. I'm not going to continue with the rest of the PowerPoint. That pretty much covers it. So, good luck to you guys, and I'm sure we'll be hearing from you.